Can you be prosecuted for wire fraud if no one is out any money? Well, as of May 22nd, 2025, under Coussissis versus United States, the answer is yes. Coussissis was a Third Circuit case that originated from, I think, the Eastern District of Pennsylvania, where a business owner obtained a contract from the state, and part of the state contract involved the business owner working with a disenfranchised business to do the contract together. So the whole purpose of this contract seemed to be getting businesses involved that needed the extra funding. Coussissis, who was the defendant, agreed to do this, and this was the whole main reason for the contract. But the business that Coussissis agreed to contract with was just on paper. They were not doing any actual work or contributing to the contract. So work got performed. The state ultimately got what they bargained for, but Coussissis did not use a disenfranchised business owner in a way that he agreed to. So he was convicted at trial. Case goes up on appeal to the Third Circuit. The Third Circuit affirms the conviction. And then the Supreme Court reviews the question of, can you be convicted of wire fraud if no one is out any money, if services were performed as contracted for, but if there was fraud with regard to a material part of the contract? And the Supreme Court said, yes, if there's fraud in the material part of a contract, you could be prosecuted and you could be convicted of wire fraud. So this greatly expanded. Now, as of May 22nd, it's greatly expanded what you can do with a wire fraud prosecution as a federal prosecutor. No one needs to be out any money. Nobody needs to be doing anything but contracting for something that does not get delivered in the material sense. So if there is fraud at the heart of the contract, you could still be prosecuted for wire fraud. If you're like, I have concerns about my business, you should probably call a criminal defense attorney to see what they tell you about your situation.